Welcome back to Cheche. Today's guest is the chairman of the Judiciary's Committee on Elections, Justice David Maraga. So we've talked about your elections, and we've talked about declining public confidence. To what extent would you agree that the judiciary is also a candidate in next year's polls?
I don't understand exactly what you mean by a candidate. I know, of course, we are stakeholders in the sense that petitions, as mandated by the Constitution, have to be filed in courts, and the court has got to deal with them. So that is what we are preparing to make sure that we do our bit. Yes.
But tensions are already running high, and we alluded to this before the break. The judiciary is beloved by one side of the political divide because you ruled in favor of them during the presidential election petition, but it's reviled by the other. Okay, the opposition, who feel that they received a bad judgment. We've talked about the admissibility of the evidence, the timelines, and so at least half of the country sees the judiciary, the Supreme Court, as being unfair.
Well, that's their opinion. You know, you can't stop people from having their views. They are entitled to have their views. But what is important is that the Supreme Court did its best. It did its best in the circumstances. Some parties are not happy with that, and that's why we are asking that let there be enough time. Let the Supreme Court be given enough time to give everybody an opportunity to be heard fairly, so that when a decision comes out, even those who lose, can be told, look, the reasoning from the judgment is you were bound to lose. And you know, the courts deal with evidence. If you bring evidence, you talked of like favoring one side. The court doesn't favor one side. The court deals with the evidence and the law. But
this is what you were saying about Kenya being the only country with such strict timelines.
Yes, the Kenya is, I don't know of any other country in the world which has that very, very tight time frame for hearing election petitions.
Was there a rationale for putting the strict timelines?
There was a rationale, as I said earlier, because of the delay that was there, of petitions lagging for a very long time. And I mean, in the Constitution, you know, the Kenyans felt that before the president is sworn in, issues to do with the petitions should be dealt with. This is not there in other countries. You know, in Ghana, which has a fairly similar constitution with ours, the petition took about how many? Is it 6 or 8 months to dispose of the presidential petition, by which time the president had already been sworn and is in office. But the Kenyan constitution is different. It provides for the clearing of election petition against the president-elect before he's sworn in. I know even when we were having the stakeholder meetings requesting for more time, there are views which came and said, look, you can't hold the Kenyan people at ransom for that long time. And my argument is, look at the American Constitution, for example. Yes. The president is elected in November, but he doesn't take office until February. Why are we in such a haste that we don't want to give the court enough time to hear the petition and dispose of it? In other countries, even in Uganda, here in Uganda, the court is given 14 days from the close of hearing to dispose of the petition, which means the Supreme Court of Uganda has 14 days to write the judgment. Ours, if you look at it, time starts to run from the time of filing the petition. The respondent has, is it five days to file his response? First of all, there is time for service, about 2 days to serve. Yeah. Then the respondent has time to file his response. Then the Supreme Court has to call the parties for what we call the pre-trial conference. When you take all that, you find that the Supreme Court is left with 5 to 6 days to hear the parties, and you saw how long it took, and of course write the judgment. If you work out that time and come to the end, you will find that the Supreme Court is left with perhaps 2 or 3 days to write a judgment. That's not, in my view, that's not fair.
So these 30 days were found to be ideal?
30 days were found to be ideal. When you deal with the service, we deal with this, that will give the Supreme Court about 14 days, which is not extraordinary. Namibia has 14 days. Ghana has 14 days after close of hearing. In fact, close of hearing, and Uganda, as opposed to Kenya.
Very quickly, this ruling, the presidential petition, you say that there must be a winner, there must be a loser.
Yes.
But I haven't spoken to the losers yet. But we see the Supreme Court attracting a lot of negative press recently.
Yes.
And those people who had sour grapes would feel vindicated by the troubles the Supreme Court finds itself at the moment. Yeah.
That doesn't really come. The presidential petition was dealt with and finalized. The allegations that have come later have nothing to do with the presidential petition.
Let me put it this way.
Yes.
I mean, since the establishment of the Supreme Court,
yes,
there has been considerable discussion about whether the Supreme Court has sorted out our judicial jurisprudential issues.
Yes.
Whether it has elevated our legal practice, I mean the judiciary's standing and
the quality of justice.
Yeah, and quality of justice. These discussions occupying the judiciary, because there have even been attempts to say, scrap it altogether. It has not added any value. It has only extended the process of obtaining justice. It's also bogged down in all these issues that have been tradition with the judiciary, corruption, and all manner of criticism against their judgments. What is there so searching around this matter? If I may put it that way.
I don't think that it is fair to say that the Supreme Court has not added value. How many advisory opinions have the Supreme Court given?
Sometimes they run away from giving advice.
No. Look, was it the senators and who?
Yeah, on the division of
the revenue division.
They did. The Senate and the National Assembly.
Exactly.
But on the one of land, they send it back to the Ministry and the National Land Commission and say, go and sit and come up with they created a court out of themselves. I mean, away from themselves.
And that is provided for in the law. A judgment sometimes antagonizes some parties.
Yeah.
Where there is provision, and in fact we encourage what we call ADR, alternative dispute resolution, where there is a matter that can be arbitrated. As I said earlier, arbitration ends up with a win-win situation.
Yeah.
There are some of those situations where the court, even not only the Supreme Court, all the other courts, we are encouraged to send parties to arbitrate. So it's not running away from that issue. In fact, that is the best way of dealing with it. So that you keep peace within the community.
But Judge, would you say the kind of hostility and negative press around the Supreme Court is normal? I mean, if you look at, for example, the Supreme Court in the United States, even when it makes a controversial, judgment, it settles the matter. Here, the Supreme Court has made rulings and judgments which people are still mumbling about, grumbling about.
What I would say is that Kenya, we are allowed in some of these, unlike other countries, we are allowed. Sometimes you make a mountain out of really a molehill.
You're calling us a nation of grumblers.
Really? I mean, quite a number of those allegations made against the Supreme Court, I don't think they are justified. The Supreme Court is there by the Constitution.
Yes.
The Supreme Court is there in very many other countries.
Yeah.
Yes. So if we can be prepared to accept that not everybody will be pleased by the decisions of the court.
Yes.
When you have lost, move on. Let's move on and proceed. So you can't have a situation where a court decision pleases everybody.
Yeah.
At one time, the advisory to Parliament, the Speaker said it's just an advisory. It's not compelling.
Yes.
And what do you say about that? It shows there's no respect for the advice.
The judiciary can't force people to respect what? To respect it is the people themselves who should be able to respect the authority of the court.
Yeah. Judge, it is that people builds into what I'm saying. That the court has not established that authority and reverence that it needs to carry for the public to just say the Supreme Court has said. People can even say it's just an opinion. Things like that ought not to happen.
Yes.
Because this is ultimately the pinnacle of justice in Kenya.
Yes. Now, where is the fault when you talk about that?
It is that people are still not having confidence that court that is subject to either manipulation or it has not settled the matters permanently the way it should have been as a Supreme Court. That's why I'm saying, people are saying, then why did we need the Supreme Court in the first place? We would have just done with the Court of Appeal the way we had. We multiplied labor and the process, but we're not getting quality and satisfaction.
Yes.
That is the argument.
You know what I talked about earlier is respect for authority.
Yeah.
Unfortunately, with the kind of the state of impunity we are in Kenya, some people make wild allegations.
Yes.
And the problem is we don't have a strict machinery of getting people to account for some of those statements, which are some of them, I'm sorry to say, can be reckless and cause problems. When you establish the office of the president, for example, you have got to respect that office. It is not going to be a perfect place because it is manned by human beings. When mistakes are made, let them be addressed in the machinery setup. You don't go into the streets and begin shouting at the top of your voices because one mistake has been made. Take the Supreme Court, for example. Most of the criticism has come from just the petition. That decision, the petition.
No, there
are others.
No, there are others.
Another one.
There are also cited. Some judges there made decisions which were not even they were not applied for. About the retirement of judges, and there was a big
reference to it in the Bomet petition.
Exactly.
Those are among the matters I told you that are right.
People to begin raising doubts about.
Sir, still on the Supreme Court, the President is a Chief Justice. He's retiring early this year. Are you finding yourselves under a lot of pressure, from the political parties and influencers as they try to, influence, the succession, trying to find judges who are friendly to them in the hope that come elections, they'll have a friendlier bench?
No. I don't know of that. I don't know of any kind of pressure on that from that front. No.
Okay.
Yeah.
I want to clear now myself from the Supreme Court about his performance.
Yes.
You allow me, Judge. Has there been opportunity? Obviously, you meet and look at the judgments, and you're studying the jurisprudence and how we are delivering justice. Have there arisen questions about some decisions which have been made by the Supreme Court that within your own setup you have reviewed and said that precedent needs to be revisited, but maybe there's no mechanism for it? Then I'll tell you why I asked.
We don't have that kind of forum. What it is that if a court, the High Court, the Court of Appeal, and even the Supreme Court, if you have made a decision in this case involving Kamau, and a similar case arises later, a different case arises later on the same legal points, and the points are raised and says, look, this decision may not be quite right continuously. The Supreme Court has powers to overrule itself.
It can vacate that decision.
It can vacate, not vacate really. What it says, look, we don't want to follow that decision anymore.
Okay.
That is there. It is there in every jurisdiction. The courts have powers to overrule themselves and change.
Yeah.
So that's the development of jurisprudence.
Has there been any particular
occasions have not arisen?
Okay.
Not
the one that has been very controversial, but I may just ask you, maybe I don't think you were on the bench that made that one, but the one that cleared that reversed the Court of Appeal decision on Kidero on the technicality of the filing out of time. The Court of Appeal had, thrown out the election, the petition had succeeded of YT2, but the Supreme Court reinstated Governor Kidero on the technicality, which
we now see playing out.
That he filed the petition out of time, the appeal out of time. That has been said to have been a gross violation of the Constitution, which says that people, that the judiciary should not adhere to technicalities, should look at the substance of justice in matters. Hasn't this matter come up for analysis within the judicial reviews or in your circles?
No, we don't review the Supreme Court judgments. But as I said, that's a live matter. We don't want to go to that one. We don't want to go into that one. But what I can say is things like timelines.
Yeah.
Those are not matters of technicalities. When you have Article 140 stating that the petitions must be dealt with within such a time, that is in the Constitution. You can't call a constitutional provision a technicality.
The matter of, like now we said, you are making certain recommendations to align the conflicting timelines within the processes of filing.
Yes.
And you are supposed to file within a certain time.
Yes.
But the court has not availed those documents to enable you to file. That was the matter here.
Yes.
These are not being aligned in your recommendations, that people are not caught on the wrong in filing their petitions after election.
That is one of the things, in fact, my committee is addressing. Why were these proceedings not typed and made ready within the time required?
Yes.
And one of the things the committee is dealing with is that the proceedings, the petition proceedings are being typed as the proceedings go on, so that by the time you finish, in fact, they should be ready and you should be given.
Actually, one of our viewers has a question around that, but this has to do with evidence and recordings. How are you addressing the issue of recording evidence by hand? Why not use a handset type recording to avoid errors and also give judicial officers time to physically study the demeanor of the evidence givers, which is important? And that's a question from Aaron in Nairobi.
That's a long-term issue which the Judicial Service Commission is addressing. We know, of course, that we should, this time and age, we should move to digitalize all our proceedings, and you know the capital outlay involved. All those factors are being addressed, and soon I think the judiciary will address that.
There are more questions from our viewers who would like to benefit from your presence here. I have an appeal case in the High Court since 2009, which has never been heard. How do I put pressure? That's Kamande in Ruiru.
Let him write to the judiciary. To the judiciary, let him write and say why. I mean, has he come himself to fix the case for hearing, and it has not been heard?
Kamande doesn't say. Joseph Kamau also has the same problem. I have a land case in Nakuru High Court that has not gone to full hearing for 16 years. What should I do to accelerate the hearing?
Yes, a matter which has been pending for 16 years. There are quite a number of things that may be, the judiciary may not even be the one to blame. So the parties themselves should be keen to have their matters heard. When you file a matter and you don't follow up your lawyer to find out whether a hearing date has been taken, I mean, you're bound to be, it is bound to be left there. But as I said, with the numbers now increasing in the judiciary, all those backlog cases are being addressed.
Okay, Robert in Kisi. Justice Maraga, are you aware that some cases are delayed because the plaintiff is timing either his judge friend or a weak judge to have his or her matter passed?
I am not aware of that. I mean, that is from shopping. I'm not aware of how they do it. So you can see, it is the parties themselves who think that they can wait for a favorable court to hear their cases, and that is one of the reasons causing the delay. Okay,
one person here complains. He names the judge, but I won't say that here. But says that they had a hearing. No, they've had a case since 2013. A hearing was set for the 25th of last month. He was told no judge is available until November. The presiding judge decided to go on leave. Ask the judge. I even wrote to the ombudsman. Excuse me, please. Excuse me, sorry. Who gave us a promise that the case will be heard. The person I sued even bragged that my case will never see the light of day. Kindly give me the way forward. I've spent so much money and no day. Should I write to the Chief Justice, seeing as the Ombudsman has not delivered any joy?
No, I mean, you can write to the Chief Justice. There's no problem about that. You know, we have people who go bragging, of course falsely, that this case I have won, I have done this, when there is nothing like that. And of course, those are among the people who give a very bad image of the judiciary. So there is really not much the judiciary can do about that. But as I told you, with the numbers, the Judicial Service Commission has advertised. He wants to recruit about 20 judges for the Environment and Land Court. It is going to ease a lot of pressure. That is where the great pressure is. You can see here, all those cases are on land. And they are being...
But there are also cases in the lower courts and the children's courts which don't move for years. In fact, there's a big problem there.
Yes, all this is because of the numbers. The judicial officers, the numbers, you know, we have a total of 444 magistrates serving how many the population in Kenya?
Yeah.
So you can see it is a question of looking at it,
or being overwhelmed.
Yes,
but there is a way in which the judiciary, in terms of quality of service delivery, it has to find a formula that is immune from manipulation of parties, where you say a case must be determined within 12 months in all circumstances, so that parties that have advantage or access to the judicial officer, magistrate, judge, do not keep matters going for long at the expense of those who are helpless, who may not have the same connections.
Yes.
There should be something around that.
I agree with you that there should be something around that. But when you want to say, okay, let this case be decided within 12 months, as you say, and you don't have enough personnel, what do you do? What do you do? But as I told you, there are quite a number of cases where we are dealing with. Some of the numbers in the backlog. You remember the CJ set up what he calls Justice at Last.
Yes.
And the judges were moved all over the country, and they disposed of 43, is it almost 44,000 cases within a month.
Yeah.
If you go to the statistics and to the files, some of those cases were actually dead cases. Somebody wants to stop a bank from selling his property. He goes to court and he seeks an injunction. When it is reviewed, he is not interested in that case. But it is there in the records showing that it's a backlog. So those are among the cases we are cleaning up, so that the figures, the false figures, are removed. Let me talk for the Court of Appeal where I sit. Right now in Kisumu, we are dealing with appeals of 2015, 2014, 2015. We have little problems here and there of getting the records for the criminal appeals, which are being addressed. I called the deputy registrars from all the stations we serve, and we have addressed that. We have now, in fact, quite a number of appeals that are pending. We are hearing them. So you can see we are moving forward. The problem is in Nairobi, because Nairobi is overwhelmed. There are so many cases that have been filed, and they have been there for a long time. And you know, 3/4 of the lawyers operate in Nairobi. So that one, the president of the Court of Appeal is also addressing. In fact, one of the ways he told me is going to explore is, once these stations, Nyeri, Kisumu and Mombasa, once they reduce their backlogs to a manageable level, they will come back to Nairobi. Malindi, I'm sorry. It is because it serves Mombasa. They will come to Nairobi for, say, a few weeks or a month, and they will deal with that. Give us time. Within a short time, I think we are going to deal with the backlogs and manage them.
Why is the court in Malindi and not Nairobi? Not Mombasa, yes.
Premises. There was no court premises in Mombasa. So, and there was already a court building in Mombasa. The lawyers have been urging for the court to move there. I think there are plans to put up a court building in Mombasa, and it will come to Mombasa.
Do you think, because of this declining confidence in the judicial system, do you think there is need for another vetting? Fresh?
I don't think so. I don't think so. The Judicial Service Commission deals with complaints on a daily basis. You know, they don't go to the public. They don't go to the public. It's just very few which the media gets to know, and they put them in the public. But the Judicial Service Commission, if my information is right, they deal with quite a number of complaints that are raised against magistrates, against judges, And as I told you, some of them are frivolous, so they dismiss them. Somebody has lost a case, and they comes up with wild allegations and says, look, I think maybe this judicial officer was in and all that, and there is no evidence, so they are dismissed. Yeah. So there is no need of vetting, because you see, if you begin saying that the judges should be vetted every other time, you're going to undermine the independence of the judiciary.
Yes. Sharon Rao told me when he was here last time that they had a stakeholders meeting where they recommended that instead of the Judicial Service Commission looking at this complaint, they should form an independent other body, some other body to deal, because the Judicial Service Commission be chaired by the Chief Justice and some judges and some magistrates who can cause a conflict of interest that we should have. There is a recommendation that we get a dependent, like police oversight authority, to look at the Judicial Service Commission.
Yeah, okay. I don't really have one opinion over the other, but once that is, if it carries the views of the Kenyans and a body is established that deals with the complaints regularly, I have no problem with that. I have no problem with that.
Would you say the vetting was effective and successful?
Yes. Yes, it was effective. I mean, there are complaints that it was not done very well. There are those, views that maybe some people were let off easily and things like that. You expect those kind of things to come up. But on the whole, the vetting was successful.
Okay, so we have to take a break now. This is Cheche. We're live on Citizen TV. Do keep sending us your thoughts on the judiciary and how it can be a credible adjudicator of next year's polls.